Welcome to Stop My Crisis. I'm your host, Vivian Gaspar. Have you started a business yet? If you have, and it's been a while, you know now is the time to get some help. But you need to start off correctly with employees. We are very fortunate to have with us today a highly experienced employment law attorney. Janette Levey Frisch has over 20 years of legal experience, more than 10 of which she spent in employment and HR law, acting as the employer's legal wellness professional. Janette has helped employers find proactive solutions to their workplace challenges and to ensure that they're in the best possible position to avoid or minimize litigation, audits, employee relation problems, which often have exorbitant costs. Janette, thank you for helping our viewers who are business owners take it to the next level with working with employees correctly.
Thank you, Vivian, and thank you for having me here. It's great to be here.
It's really good to see that this is the step that they know what are the right ways to get started. So first and foremost, pre-employee screening. What are do's and don'ts of, well, let's get an ad out there?
Well, there's a sweet spot that employers have to sort of hit because on the one hand, whether it's advertising or the interview, when you have the candidate in and you want to ask them questions, you want to do your due diligence on one hand, make sure you're making a good hire. Then on the other side, you want to avoid a discrimination claim. So how do you do that? There are certain questions that you ask on an interview, you're asking for discrimination claim. So there are certain questions that I would say either don't ask at all or wait till after a conditional offer of employment. So with respect to anything that could reveal that somebody has characteristics like their religion or a disability or their gender, anything that focuses on that, should not be asking about it. Keep it related to the job. Keep it related to the qualifications for the job. And other things such as criminal history or medical issues, if they're relevant to the job, extend a conditional offer before you start asking about those issues. That will minimize discrimination and also help protect an employer who's seriously looking at somebody and trying to help them make a good hiring decision.
So you've been doing this a long time. What are the most common accidental discrimination that people do? Because I think a lot of times discrimination, I always think it's more like race related, right? That's what I think people think most commonly of. But what about inadvertent sexism?
Ooh. I have a story of my own with that. Actually, when I was looking for a general counsel position, I went in on an interview, and the gentleman who's interviewing me was trying to be conversational, and he's talking to me, and says, "Oh, you have any children?" And I looked right across at him, and I said, I would be remiss, since I'm interviewing for a general counsel position, if I didn't tell you that you really shouldn't ask that on an interview. And he was flabbergasted. He thought he was being nice and making conversation. That's not relevant to the job. It's not something to ask, especially on a first interview. That's a very interesting accent. Where's what kind of accent? Don't ask. You can open yourself up to a national origin discrimination claim. Things like that. Keep it related to the job functions.
Okay, so people might think, what's wrong with asking if you have children?
Because if you ask a woman if she has children, and let's say you don't hire her later, or you do hire her, but then something else happens, and then she claims that your decision was based on her response to that question, how are you going to prove you didn't base your decision on her response? You're proving a negative. It's kind of like, when you say something, you can't unsay it after that.
Well, they also might think, well, you're asking a woman, do you have children? Do you ask a man the same thing? And
yes.
Immediately it will go to, oh, can she work enough hours? Will she have emergencies
yes.
because of children?
Absolutely.
You don't
yes.
realize that's actually sexist, even though there's plenty of single fathers nowadays.
Very true. Yes. So all of the things that you just said, and so many other issues, even a question, if you ask somebody, what do you do in your spare time?
Oh, really? You can't even ask that?
Well, I won't say you can't. It's not a good idea because maybe that will reveal the person's religion. Oh. Maybe it will reveal their marital status, their sexual orientation, their gender identity. You're doing that probably because, well, maybe you're a little nervous. You're interviewing somebody and, so you're trying to make conversation and trying to fill the gap. So even if you have to write it out a little bit beforehand, think about, have the job description before you, and keep coming back to the job description, the main functions of the job. That's really what the focus should be at a job interview, especially before you made an offer.
What about asking if they have reliable transportation? Is it okay to say, well, do you have a car that you can get here?
Well, the way you could phrase it is you could say to somebody, listen, we're not really near a lot of public transportation. And, our location is such and such. So it really is important that you have a reliable way to get here. And these would be the hours, and you work it into that. Do you foresee an issue with that? That's how you can get into that. There are some people who would say there are a lot of people in certain classes that don't have cars. So you don't have to ask if they have a car, but do they have a reliable way of getting here by whatever time the day starts?
I mean, if so many people have brought up the concept of protected classes.
Yes.
But truly, almost everyone could be deemed a protected class at this point.
Generally speaking, when we're talking about protected classes, I hear what you're saying. Generally speaking, a protected class, we're talking about race, religion, national origin, sex, of course.
Sexual orientation.
Well, yes, although interestingly enough, under federal law, that is not explicitly protected.
Really?
Yeah, and that's
Oh.
been actually the courts are split on that. The U.S. Supreme Court has yet to decide that issue and is trying very hard to sidestep that issue.
Oh.
Yeah, so you have the intermediate courts, the appellate courts, and those circuit courts are split on that. Some say it is covered, some say it's not.
So what is just one or two tips that what employer could do to make a good hire or at least avoid making a bad hire?
If I had to boil that down to one or two tips, I would reiterate that if you want to do a criminal background check, which I think is a good idea, by the way, especially in certain positions where maybe someone has access to money or sensitive information or safety is a particular concern. So I would say by all means do the criminal background check, but wait until you extend a conditional offer of employment. So questions like that should wait. Other questions, you can ask somebody to describe or demonstrate how they might perform certain functions. If you want to get around that to get a better idea of how they would do a job without getting into all of that other stuff that could really get you into some hot water. So those are two things I could think of.
Well, these are important tactics or strategies to make the right hire. So we're going to take a break, and we are going to discuss next, after our short break, the right way to interview and perhaps hire. But when someone's interested and you've chosen the right hire, let's take a look at the right ways to extend that offer coming right up after a short break.
Let me share a secret. Financial planning doesn't have to be complicated. I'm Brian Cody, certified financial planner. And at the end of the day, we're really trying to do two things: create growth and manage risk. Together, we can create a plan that not only includes your investments, but your lifestyle and goal of financial freedom. At Cody Financial Advisors, we will help you create the plan for your life.
Welcome back. And right now we're learning that after you find the right hire, how do you move forward with them? So Janette, when is the right time to do an offer letter versus an employment agreement? Or do you do both?
Ideally, I would want to see my clients do both, or at least provide an offer letter to everybody. And there's a difference. They're very, very similar documents. The offer letter, however, is more what it sounds like. It indicates the position that you're offering the person. So there's a title and a start date and the salary and the benefits. So just the basics that a person would be going into, and they know what they're getting, basically. That's the offer letter. The employment agreement goes into more detail. And that would be something that an employer might decide they don't need to do that with every single employee. You might not feel a need to offer a maintenance person or a mail clerk an employment agreement. But with many of one's employees, I would say it's a good idea because it spells out the relationship from the beginning, the understanding of the parties, and it gets into issues of what kind of information the employee might have access to, what needs to be kept confidential, what happens if it isn't. Other things that might be unique to that position, you would want to put that in an employment agreement.
Is that where you could spell out behaviors that they would expect from an employee? For example, information they may or may not or should not share, for example, on social media?
That could be in there. That might also come into an employee handbook,
Okay.
which perhaps momentarily we can get into.
we can talk about that in a second.
Sure.
How about, is that where you'd put an NDA? We talked about earlier, we could talk about non-disclosure agreements and along those lines?
That would certainly be an appropriate place to have a non-disclosure agreement, which in short term is referred to as an NDA, and defining what exactly is going to constitute confidential information, because that can mean different things for different businesses. For some businesses, it could be formulas or patents, patented information. It depends on the business, and it also depends on what that employee was going to be doing for that business.
So it's role specific.
Very fact specific, very role specific, yes.
What are the key benefits and why you should use that versus a handshake and a hire? What would be the pitfalls of not?
Well, if you think about any situation where maybe you have hired somebody to do work for you, maybe it wasn't an employee, and you did business on a handshake. And then what happened later when you had some questions, you have some misunderstandings, you have nothing you can refer to. So your agreement is something you can look back, you can refer to right away and say, okay, well, what does our agreement say? Because that's the first place you would look at. And if you don't have that, so you don't have that safety net. And if you have a well-written employment agreement, it can smooth over a lot of those wrinkles or maybe even avoid them in the first place.
Is this something that you commonly provide to your clients and versus if somebody just writes it up themselves versus using an attorney?
I commonly provide them, I commonly review them. And so sometimes I will get a client that will call me and say, I wrote this up, can you look at it? And then usually we have a little understanding there. I say, I will look at it and I will try and work with what you have, but if it gets to the point where I would have to rewrite it, then I'm going to ask you to please let me use what I would start with. So that's also fact specific. It depends on what they come to me with. So the answer is I do both.
Great. So coming up on the idea of an employee handbook, I think that's a whole topic we need to delve into.
Sounds good to me.
After this short break, we're going to talk about employee handbooks and why you may or may not need one.
52% of Americans say they are unhappy with their job.
Oftentimes people are in a job or maybe they've just lost their job, and I have easy ways for people to lean into starting their own self-employment or working in an industry that they're really excited about.
If you feel unsatisfied in your work, Mary McNutt can help restructure your current job or help find your passion and build a career centered around what you love. Don't waste any more time. Your new career is right around the corner.
Welcome back. We're here with Janette Levey Frisch, and she's an employment attorney who's here to share with us the importance of why to have an employee handbook. What happens if you don't have one?
Well, particularly if you don't have employment agreements with all your employees, then you have no document that outlines the expectations. So the importance of an employee handbook is that your employees have some idea of what they can expect when they come to work for you. And there's also one very big piece that you have in an employee handbook, and that's known as an at-will disclaimer. And that's very important because that tells the employee you are an employee at will, meaning either the company or you can end the employment relationship at any time for any lawful reason or no reason at all. And so the employee handbook is a great place to spell that out, but it also gets into a little bit, it could be a description of benefits. It can be also talk about paid time off and what paid holidays one might have, and all of those things that you might look at where an employee might have questions about what it might mean to work for your company. And that's your chance to put it in the employee handbook. That would be something that you give to all of your employees. And that would be, again, that's for the employees. That is not a policy and procedure manual. That's for your management. That's how to carry out your different policies and procedures and whoever is going to be implementing those policies and procedures.
Is there any size company that you would recommend to have this, or is there a size company that say, it's too small, you don't have to worry about it?
I mean, if you have one employee, it might be you're at a point where you might not feel you need it yet. Once you start taking on a few more employees, it's a good idea to have it. And yes, it does take time, it does take effort, but you're putting in the effort now at the front end so that at the back end you're not getting hit with all of these issues, because you can then refer to your employee handbook. The other piece is that, unfortunately, you do have a situation where you have disgruntled employees. Maybe they sue, or maybe they file a charge with a local agency, a state agency, and the first place these agencies are going to look, and the first place where a court's going to look, is your employee handbook. What does your employee handbook say?
What about, did that also curb any potential lawsuits based on discrimination? So even if you have one employee and you think you don't need this yet, or two, but now what if you have 5, 6, or 7, and the first two, before you implement it, to say, well, that doesn't apply to them, or they could say they're exempt from it. Maybe there's those reasons to have it from the beginning?
It could be. You can also state in the employee handbook that this particular section applies to this particular employee or group of employees, usually. For example, you may have a business that has a union on premises. In that case, it's going to be the collective bargaining agreement that's going to govern with respect to those employees. So you can have a disclaimer in the employee handbook that states that in the event of a conflict between the provisions in the employment agreement or the employee handbook and the collective bargaining agreement, the collective bargaining agreement will control. But that's with respect to the employees represented by the union.
So if there's no union, let's say, for example, it's a very small company, 5, 6, 7 employees, you're starting now to grow and take traction, is this the right place to put behaviors that an employer might be concerned about could happen? So for example, cell phone usage for personal, does that go in there? Social media usage at work?
That would be in an employee handbook. That's certainly more appropriate there than the employment agreement. Employment agreement doesn't go through all the minutia of employment. Those are just certain key points that you include for your protection if you feel there are things that need to be protected. The employee handbook, yes, that's an appropriate place for social media, cell phone usage, and related topics like that. And the other provision that is important to have in there is this is not a contract. All right, so this is, the employee handbook is to give you information about what you might reasonably expect working here, but management reserves the right in its sole discretion to change the provisions at any time. So hopefully that's the difference between these documents.
Do your employees sign to accept that those behaviors or expectations on them? Is this a signed document?
It's a good idea to have an acknowledgement of receipt that you get the employee to sign. And even if they don't actually read it, and by the way, not reading it is not a defense. That does not mean that they are not responsible for knowing what's in there. You can't make employees read a handbook, but you can and should get a signed acknowledgement of receipt.
So does the signed acknowledgement of receipt just acknowledge that they received it, or acknowledge that they read through it and agreed to the terms set forth?
It's an acknowledgement that they received it. And you can't control everything, and you can't make the employee read the employee handbook. If you can get a read receipt, hey, that's great. But at the very least, they received the employee handbook. If they then chose not to read it, that's on them. That's not on the employer. Because then if you think about it, every employee would be able to say, well, I didn't read it. And, oh, you didn't read it? Well, okay, then you're not bound by any of this. That kind of defeats the whole purpose. And that's not what we're looking for. That's not what the laws are looking for.
Well, to protect businesses, that's one tactic, and we're going to take another break. And after this, we're going to learn that if a relationship with an employee does not work out, what is the right way to terminate or separate from your employee? Welcome back. We're here with Janette Levey Frisch, and we're talking about if it's not working out with your employee, what is the right way to separate, both voluntarily or termination?
First of all, obviously there's a difference between voluntary and involuntary termination. So I just want to make that distinction. Voluntary termination occurs when an employee decides that they are leaving, hence voluntary.
They quit.
Yes,
They quit.
yes. And that can happen in pretty much any way as long as they get their point across, including somebody can, if they wanted to, they could fax in their resignation. I would not recommend that. It's not really the right way to do it, but
Hey,
it could happen.
Is it a Post-it note?
Could be, but I don't recommend it. It's not really nice, but it does happen. It's been known to happen. So that's the voluntary side. The involuntary side is when the employer, for different reasons, whether it's cause, performance-based or conduct-based, says, we need to part ways. Or maybe it could be not for cause. We don't have any money. Which is a very good reason to let somebody go. Unfortunate, though. Now, there is something, though, known as a constructive discharge.
What is that?
So that occurs when an employer is either, if there's harassment or discrimination, the employer either commits it or permits it in the workplace. And things are so bad that the employee quits. They just can't deal with it. So, the classic example would be somebody who is subjected to sexual harassment every day. Maybe even, God forbid, is assaulted, if you want to take the most extreme circumstance, and the employee quits. So the employer there tries to argue that's a voluntary termination. She resigned on her own. We didn't fire her. Yeah, you know what? That employee has a good claim for harassment, discrimination, and constructive discharge by way of the harassment and discrimination. So that's an important thing that I would want employers, and I tell my clients to keep that in mind. That's why you want to do something about harassment and discrimination, especially if you have reason to know about it.
What's the right way? If you need to fire or terminate an employee, what's the right way to do it? For example, time of day. What's the right time of day to do it? Or which day?
Or which day? Well, all right, I would say in general, time of day, I would want to see an employer do it at the end of the day when everyone else has left, or almost everybody else. You should have a witness there in the room with you, so that this way it's not one person's word against the other. And maybe someone else that's in the building if there's reason to be concerned about safety. Maybe you're dealing with somebody that you know is a little volatile or unstable. But also in general, I would say that the best, it sounds terrible to say the best way to fire somebody, the right way to terminate somebody is do it with consideration for their dignity.
So what do you mean by that?
In other words, that's another reason why you don't do it in the middle of the day. And don't have them escorted out there in the middle of the day in front of all the employees, having them do the walk of shame, and it has happened. Doing anything where you're going to increase the chances that that employee is more disgruntled than he or she needs to be. Because disgruntled employees are the ones who are more likely to sue or, God forbid, return to the workplace and engage in behaviors that we unfortunately hear about in the news, shootings and things like that. So these are some things that an employer can do to minimize that risk.
So what is some procedures you should implement right before letting someone go, termination?
Well, I would hope that with most terminations and most employees, it shouldn't come as a real surprise. And that means that the employer should be in communication with the employee well before the date of the termination if there are issues with performance or conduct. And giving the employee a chance to improve and documenting everything that the employer is doing to, show that you communicated with the employee, you gave him or her every chance, and literally, hey, this is our last resort. Need to be thinking about the fact that somebody else might be looking at those records of yours, as to what you did leading up to the termination.
What about changing their email address or making it discontinued? What about changing passwords if they have access to, hypothetically, a Google Drive, access for the business?
Upon firing the employee, as soon as you have fired the employee, then I would say for sure you have to make sure they no longer have access to intranet, if that you have that, or company website, any other confidential information. Email, definitely their email should be deactivated, and the password, whatever it is, yes, absolutely. Your IT people will have some work to do, but very important. Yes, and also consideration maybe for how many entrances you have in the building? Do you want to do anything about access?
Like a fob, like if they have a key fob.
Have them also, I would say, return company property immediately. The other thing that one can do to kind of soften the effect and minimize the chance of a disgruntled employee, a severance agreement with a release of claims in the severance agreement. This way, it kind of softens the impact of the termination, especially if it's not for cause. Let's say it's for financial reasons. That sort of employee who's got the severance payment and feels they're being taken care of is less likely to sue. And if you have the release written properly, they can't sue.
Excellent. So now we've covered the ABCs of having an employee. So you have from the point of right entering techniques to if you have to terminate and let someone go. So Janette, I really appreciate it because in order to help a business grow, thrive, and move up, they need to know these things. Thank you very much for watching Stop My Crisis and learning how to help your business thrive with having employees here with Janette Levey Frisch.